Hey everybody, I'm Chris, and this is another Lexplainer brought to you by Nomad Law. The topic for this video might be a little bit self-serving, but it answers a question that I think a lot of people have, and that's, do you really need a lawyer to file a trademark application? Well, let me buy myself a little bit of credibility right off the bat and say no. People can and do file their own trademark applications all the time. Now, you can't file somebody else's trademark application. You need to be a lawyer to do that. But a business owner can file a trademark application on behalf of the business. They're called a pro se applicant, just like somebody who's representing themselves in court. And it's in fact not even really all that hard. You can do it online. You just go to uspto.gov. Then you just find the online application. It's called TEAS, the Trademark Electronic Application System. Select the type of form you want. I usually go with TEAS Reduced Filing, but some businesses might be able to get away with TEAS Plus depending on their situation, and away you go. Shouldn't take really any more than an hour, maybe a little bit more than that to prepare your specimens of use. But here's the thing. A lot of pro se applicants screw it up. And screwing up can mean one of two things. It could mean that the USPTO just rejects your application, so you've wasted your filing fees, and more importantly, you've lost your priority date. So theoretically, somebody could jump your place in line during the 9 months or more that an application is pending before it dies. But the other thing that screwing up might mean is that, maybe your application is granted. You get your registration and you give yourself a nice pat on the back. But then years down the road, you try and enforce that registration and you find out something's wrong with it. Maybe it's invalid for some reason. Or more likely, maybe it doesn't cover exactly what you thought it covered. Maybe the scope of the registration is a lot narrower than it could have been. But if you're going to file a trademark application on your own, let me give you a couple of tips to help you avoid the most common pitfalls that pro se applicants sometimes fall into. One mistake that is sometimes made right at the start is filing an application that has no chance of being granted. And that might happen because the applicant has chosen a trademark that is just unregisterable. The USPTO will refuse a mark for a variety of different reasons, but two really common ones are one, that the mark is descriptive, or two, that it presents a likelihood of confusion with a prior registration or a prior filed application. Another common mistake is choosing the wrong mark. The USPTO gives you a lot of different options in how you represent your mark, so you have to decide. Do you want to claim just the words, or do you claim the stylization on the mark? If there's a logo or other design elements, do you apply for those together with the words, or do you apply for them separately? Do you go color or do you go black and white? Those are all decisions you have to make, and they make a difference in how broad or how narrow the resulting registration is. Along kind of similar lines, another part of the application that sometimes confuses people is the part where you have to identify your goods and services. Every trademark applicant has to identify the specific goods or services with which their trademark will be used. And you have to classify those goods and services into one of 40 plus classifications according to something called the NICE classification system. And the identification has to comport with the USPTO standards for how certain products should be described, which can be kind of complicated. And again, the goods and services identification can have a big impact on how broad or how narrow your registration is. And if you screw it up, it can even result in your application being rejected. Another thing to watch out for is your specimen of use. A specimen needs to demonstrate use of the mark in commerce. And there's a whole set of rules and procedures about what constitutes an acceptable specimen of use, what does and doesn't demonstrate use in commerce. And again, if you submit an improper specimen, the application may be rejected. Finally, what I think a lot of pro se trademark applicants don't realize is that the job isn't done when you hit submit on the application. The USPTO will examine the application, and if there's something wrong, or sometimes they just want to make some adjustments to the application, they'll issue what's called an office action. I think the statistics are that something like 80% of applications get at least one office action, so it's pretty likely. And in fact, many trademark attorneys will purposefully provoke an office action because the thinking is, well, you don't want to make any concessions until you have to. You want to have the broadest possible trademark claims, and if the USPTO forces you to narrow them, then you do it then. Regardless, when you get an office action, you've got 6 months to respond, either doing the things that the examining attorney asks you to do or arguing that it shouldn't be necessary. And if you don't respond within those 6 months, the application is abandoned. And I see a lot of pro se applications abandoned needlessly, when really it was something that was just a very simple fix. So those are some of the big things to watch out for if you insist on filing a trademark application yourself. For more information, check out our website and our blog, or reach out to us on Facebook, Twitter, and so on. Thanks for tuning in, everyone.